Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Hi, welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Real Estate Group, and today we're joined by our host Jim York and his guest Celia Defik, attorney with the law group Ross, Lanier and Defik.
Thank you, Morgan, for the introduction. Well, Cecilia, thank you for coming back on the show again.
Happy to be here.
Let's just tell our viewers that haven't seen you in our previous shows, just tell us a little bit about yourself.
Well, I've been practicing law in Florida for over 3 decades. I'm with Ross, Lanier and Defik downtown. I specialize in litigation of real estate issues. I litigate some business issues, but basically if it concerns dirt, I've litigated it.
Well, that's interesting. Where's your offices located?
We are downtown. We're in the Capital Bank building on the corner of 6th Avenue North and 41, right across from Pastrami Dan's. That's the landmark. Everyone always says, oh, I know where that is.
Yeah, that is a great place. So I know in previous shows you talked about your certification. Maybe you could just talk about your certification, because that's unique to our being an attorney, right?
Well, yes. I mean, many professions do have what's known as board certification processes. When you go to a physician, you'll often find you're directed to a physician who's board certified in cardiology or things like that. And the Florida Bar adopted this quite some years ago, and it has expanded to various topics. And it's basically a way of demonstrating, number one, that you're specialized and have adequate education and knowledge, and number two, that you're well regarded by your peers, by the judges, by the other attorneys. You don't have disciplinary actions against you, you haven't gone to jail, these kinds of things. But it's a bit more than that. I was board certified in real estate first in 1990, and that requires a couple of days of exams. The Florida Bar investigates you. And then every 5 years, you apply to be recertified. You have to prove that you've done a certain amount of education, a certain number of hours of classes and things of that nature. And they do a new survey of people in the community to, ascertain whether or not you really do the work that you say you do, and if you're held in high regard. And so it is a way of the Florida Bar providing a tool to consumers. Say, if you're interested or need a family law attorney, you might want to look at someone who's board certified in matrimonial law. If you're looking for someone to assist you with real estate issues, you might want to select someone who's board certified in real estate law.
Yeah,
so
that's quite a distinction there. So
well, it certainly keeps me busy.
Well, we have you on the show today to talk about a subject that kind of, it's not a fun subject, but it's something that does happen to people. It's foreclosures. So we're going to step people through, if they ever do, God forbid, that they ever do get foreclosed, but there is certain steps that you need to walk through, and the first one would be is to talk to an attorney.
I would say even before talking to an attorney, read what is served on you. I know you and I talked about this before.
Right.
One of the things that, and certainly you should seek counsel, you should act. But one of the things that I have observed over many years of litigation is that when people are themselves involved in a lawsuit of any type, they become paralyzed. They are so emotionally upset that they look at papers and can't absorb them.
Right.
So yes, I would say read what you receive. Consult an expert, consult an attorney, act. Don't let yourself just be paralyzed.
So the first, if somebody is behind on their payments, their banks obviously wants to get their money. So they file for foreclosure and they're served with some papers. So maybe let's start with the paper that they're served or how they're served. Maybe you could tell our viewers a little bit about that.
One of the recurring themes that I see with clients who come into our office is they've been served with a summons. On the summons, in big letters, it says, you must respond in writing to the court and send a copy to opposing counsel. And yet over and over again, when people come in and I ask them, did you respond to the court? Their answer is, oh yes, I called the bank. And they're confusing the two.
Right.
And I've had people come in, I had a lady come in with a notebook of letters she'd written to the bank. And I said, that's not my question. My question is, did you file anything with the court? No, I didn't know I needed to. And so of course, judgment had already been entered against her.
If you don't, it's 20 days you have to respond. So let's say, you know, they're emotional about this and they don't wait, 6 months, but they do wait 30 days.
Sure, the courts are very flexible.
They are flexible?
The courts are very flexible, and if you have any type of explanation, the court will, number one, if you ask within the 20 days for extra time, the court will always say yes.
Okay.
Now, certainly you don't want to ask 3 times.
No, you don't.
Right. But if you've missed a deadline, and even if a default has been entered against you, if you hire counsel and you have meritorious defenses and a reasonable excuse as to why you didn't act, the court will set aside the default and let you plead. What I tell clients is the courts are there for you. The courts are there for the citizen. And you should never feel shy about attending any proceeding concerning yourself or participating in the court process. Now, certainly it is important to have counsel and do it appropriately.
That's right.
The other problem that I've seen, particularly with foreclosures, is people who do respond write a hardship letter. They've heard this term, the banks request it. That has nothing to do with the court process. So if I could get across a message, it would be read what you get, act, and get someone to assist you with legal defenses. A hardship letter or an answer that says, I lost my job, it may
that's good for a loan modification.
It's not going to help you. The judge may have compassion for you, but it's not a legal response. And in this recession that we've undergone, we've really been at a unique point in our history where these loans have been transferred 1,000 times. There really are meritorious legal defenses that can be brought up if you consult counsel.
Well, before we get into those legal defenses, we're going to take a little short break and we're going to be right back in 1 minute.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York real estate group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Let's continue this legal defenses. Before we get into legal defenses, the person might have been trying to sell their home as a short sale because if they're behind in their payments, they have to disclose that. They can continue to try and sell their home even if they're in foreclosures.
Absolutely, they can. And what people need to understand is they own the home throughout the foreclosure process. They are the owner of the home until a certificate of title is issued. And Jim, not everyone is upside down anymore because
That's
the real
right.
estate market has gone up considerably. So, but yes, you can continue to try and sell your home. But that doesn't mean that you don't pay attention to the court process.
No, you have to do both at the same
Right.
time. I've had, we've done a lot of them over the years, so if people think they got served, they can't, or, we can continue to sell the property.
Sure.
We've closed some the day before the sale.
Absolutely.
So, I mean, it's a lot better for them to do a short sale than go through the foreclosure
Well,
process.
the other thing that people may not realize is if you have a short sale approval and a valid, fully executed contract,
Right.
you can ask the court to extend the sale date, and often they will. And sometimes the bank will cooperate in that. Now, certainly it's best to do that before
right.
the final hearing or trial, which, again, I find so many people come to see me, they say the numbers are wrong, these allegations are wrong. Did you go to court? No. Did
No.
you attend the trial?
No. So what is their legal defense once they get served?
Well, certainly it's going to vary depending on the case. But what we have seen are a variety of things. First of all, very often in the residential mortgage market, the entity, the plaintiff that's suing the borrower is not only not the original lender,
Right.
there are several lenders down the chain, and they are actually, everything's actually being done by a mortgage servicer. So the first question that comes up is what we call standing. Is this plaintiff the right party to bring the suit? And that's been a very fertile area of litigation. For me, it's been unusual because I like to say in my previous life before 2007,
Right.
I had done foreclosures for local banks. And when I got into this, I thought that it was going to be like it was in the 90s. But it's very different. It's very different. The loan servicers frequently do not have the appropriate paperwork, and sometimes they actually don't own the loan or have a right to enforce it. Another thing that can be raised, well, I mean, there's the obvious, the numbers are wrong, or
Right.
payments were made, or legal description. I won a foreclosure hearing because the bank attorney went through the entire thing, and the judge said, "Ms. Defik, you're uncharacteristically quiet." I said, "Well, Your Honor, if he wants to foreclose a house in Miami-Dade County, we don't care. My client's house is here in downtown Naples."
Right.
So word processing, is the downfall of many foreclosure mills. But the other thing that needs to be looked at is over the last 8 years, the Florida Supreme Court and the Florida legislature became very frustrated with the loan servicing entities and the law firms that were bringing, huge numbers of suits because everything was in such disarray. So now there are fairly strict rules and laws, both, that say if a lender is going to bring a residential foreclosure, they have to jump through all of these hoops. And usually if a borrower comes in, a homeowner comes in, I can look at the complaint, I can look at the paperwork, and in 5 minutes ascertain whether or not it complies with these laws. And that's a much more meaningful defense than I'm out of work,
Right.
I've been ill, those kinds of things. All of those are points of compassion for the court, but the court is not there to provide compassion. The court is there to look at the law.
Right.
And I have seen local judges be really diligent about looking at the documents if someone brings it up and saying to the lender's counsel, "This is wrong, you can't proceed on this, go back to the drawing board." There are quite a number of other defenses that can be raised, and I think the best thing I can say here for the layman is, please talk to someone who is knowledgeable and talk to an attorney who is in court all the time and understands litigation practice, understands the rules of procedure and the rules of evidence, because a transactional attorney may be lost in the courtroom.
Yeah, the experience
always
helps, right?
Right. Well, they have a very different sphere of expertise.
Exactly. We're going to take a little short break, and what I want to do is come back and talk about condo associations doing foreclosures and tax certificates if they didn't pay their taxes. And
Absolutely.
we'll finish the last segment with that. We'll be right back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York real estate group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Let's talk about a case that you just brought up. Tell us a little bit about that.
Well, the Florida Supreme Court just issued an opinion last month in a case called Bartram, and it's about the statute of limitations. Statute of limitations is a $64 word that basically means deadlines. In the law, we have deadlines for bringing lawsuits because the law favors finality. If you have a cause of action, bring it now. Don't wait 10 years till your witnesses are dead or have moved out of state. So one of the things that has been a huge area of contention is the 5-year statute of limitations on mortgages. The statute of limitations, or deadline, for bringing a mortgage foreclosure is 5 years from when the loan was accelerated, which means when the bank or lender demanded the full amount. So what we've had happen over the last 8 or 9 years is a lot of mortgage foreclosures were dismissed, voluntarily or involuntarily. And now we have a backlog of delinquent mortgages where the homeowners may still be in the home and the banks are not getting paid. So the banks have brought second and third rounds of foreclosure suits. And what has happened is attorneys such as myself have raised the statute of limitations. And there's courts in Florida that have said a lawsuit, a foreclosure suit, is barred because the bank had their chance and blew it previously. Now, what has happened is this issue has wound its way through the trial courts, the appellate courts, and finally to the Florida Supreme Court. Florida Supreme Court has now said that the bank can sue again and again during the term of the loan plus 5 years, which means if you have a 30-year mortgage, the bank has 35 years in which to bring a suit. But the Supreme Court limited this opinion to a certain type of Fannie Mae residential mortgages and only to certain actions under them. So you really need to talk to an attorney to see whether or not a later lawsuit might be barred. So this has made a huge impact on the state. But again, I think a lot of people don't realize the opinion is limited.
Okay. Let's, a lot of homeowners associations or condo associations haven't been paid. So if they're behind on their payments, they're behind on their condo fees.
Right.
What can that effect have on the owner being in foreclosure?
Well, I tell all my clients, pay your homeowner association dues, pay your condominium dues, because the association can foreclose on you much, much more quickly than the lender can. and the association will foreclose. Because think of it this way, you have an association with 100 units.
Right.
During the depths of the crisis, they might have 40 units where the people are not paying their mortgage and also not paying their assessments. That shifts the burdens to all the others.
That's right.
Right. So one of the ways attorneys who represent condominium associations have sought to mitigate the damage to their association is to foreclose before the bank does. And a lot of people don't seem to realize that the condominium association or homeowner association can foreclose your home, even if it's just for a $200 assessment. And they can get title. The association becomes the owner and puts the owner out. They can then utilize the property, rent the property out until the first mortgage holder gets around to, if they ever do get around to, bringing a foreclosure. And there have been some huge lawsuits over this. And one of the things that is a big issue is the safe harbor provision. You'll hear that term. The statutes say that if the first mortgage lender does eventually foreclose, they have to pay the association 1 year's worth of delinquent dues.
That's right.
Well, when that law was passed 15, 20 years ago, that was considered marvelous. But now condos haven't been paid for 5, 6, 7 years, which is why they've become much more aggressive.
Is there any time period that the condo association can start the foreclosure if they're just behind 1 quarter, or is it a year, or is there any statute for that?
Well, there certainly are statutes on it, and the condominium, first of all, has to place a lien. There's actually some older condominiums where they don't need to, but that's kind of a weird scenario. First, the association has to place a lien in the public records and send you a copy of it.
Okay.
They're supposed to give you notice in advance of any intent to foreclose, at least 30 days notice. If they fail to give you the 30 days notice, then they will have a hard time getting their attorney's fees when they get judgment. So yes, there are some strictures on them, but again, we've kind of been in the wild, wild west.
That's right. How about if they don't pay their taxes? Just explain to our viewers a little bit about tax certificates. What happens in that case?
Well, the other thing I tell borrowers who are facing imminent foreclosure or in the midst of a foreclosure proceeding is you need to check on your taxes with the county every year. Don't depend on the bank paying them. What we have seen over the years is that the lender will generally go ahead and advance the money and pay the taxes, and they will also force place insurance if you don't keep your insurance up.
Right.
I would prefer my clients pay their own insurance. That may be another discussion. But if taxes aren't paid, and I've seen banks cease paying them, they'll pay them for the first 2, 3, 4 years, and then they'll say, no more, we're not going to do anymore. If the taxes aren't paid, the clerk will sell what's called a tax certificate to someone who volunteers to pay the county. The person who holds that tax certificate has to wait 2 years. If after 2 years the homeowner has not made good by paying back the county who pays back the certificate holder, then the certificate holder can apply for a tax deed. Tax deed is far worse than a foreclosure. If the certificate holder applies for a tax deed and does it properly, they have to pay all the other outstanding taxes, and then they can get a deed to the property, and they wipe almost everyone else out. So it's something you really don't want to fool around with.
Well, I'd like to thank you for coming on the show today, but before we end it, tell our viewers a little bit about your website and information they can get from it.
Sure. Well, I have a blog at NaplesRealEstateLitigationLawyer.com, And I have a website, celiadifik.com, which actually I'm a member of Ross Lanier and Defik, and we have a website. We're trying to combine them. But people who have questions about real estate issues, particularly related to litigation, will find I have a lot of articles about different topics on my website, and I blog regularly about real estate and real estate litigation issues.
Well, thank you for coming on the show, and I look forward to you coming on the next show, I guess, in February.
All right. Well, thank you.
Thank you.